computer. There we go.
It sure is.
All right. Well, welcome everybody to the inauguration of NexGen Virtual here. And it's NexGen on day 91. People might want to know what day 91 is all about. And the way I look at life right now is that things are so up in the air, changing daily, that we need a 90-day plan to get to our 90-day plan. So it's one day after our 90-day plan to survive our 90-day plan. So we're going to have a whole series of speakers. They're going to always be on business topics. The mission is going to be 3 or 4 takeaways that you can apply to your business right now to make a difference. The first speaker is Lisa Spiwak, from Spiwak, who is a fabulous collection lawyer, and besides that, a really nice person with tons of energy, and is passionate, very passionate about collections. So I've taken up only 1 minute, but I'm going to let Lisa do a little introduction, and then I'm going to have you jump right into it.
And before we do that, what I'd like to do is share with everybody how we're going to run this particular gathering. We're all very used to going into chat and having a lot of cross conversations. We're asking that you not do that, but rather use the chat, because we're going to pose a few questions to you. So as Lisa, as our speaker today, is talking, please put the questions that you have inside the chat. Put the letter Q and then your question. And then once she's done, I'm going to go in there and identify the questions and ask you to unmute yourself, explain the background, and pose your question to Lisa so that she can answer it. So if that makes sense to everybody, give me 2 thumbs up on screen so we can see it.
You bet.
Great. Thank you.
And mute yourself. And then I just set up a quick poll, and I'd love to hear if anybody's got opinions on. So, and I am going to end the poll in 5, 4, 3, 2, 1, and I'm going to share the results. So there you go. Lisa, you can see what. So
yeah, I'm not surprised by that. That's exactly what I would have anticipated the response would be.
Okay. So Tom, back over to you to create the introductions and kick us off today.
Oh, thank you. So back to the introductions. The people here are all from NexGen. And so just real quick, we've got Dean Wilson, who was a manufacturer, now is a consultant. We've got Jess Johansson, who's a fabulous insurance broker for IOA. We've got Tom Grace, who works with Lucas Horsfall, and it's not Lucas anymore, it's Horsfall. Help me, Tom. Anyway, and we've got Kenneth Dunn, who does communications. We've got Jim Tordahl, who does sourcing in China and business consulting. And we've got Linda Feinholz, who does help people create value in their businesses. So with that in mind, we're going to throw it over to Lisa.
Okay, a lot of you guys already know me, but just really quickly, I'll give you a background. So I am a collection lawyer. I have been practicing law for 34 years, and I have always specialized in this area. I've done collections since the very beginning. I am a partner in a law firm that specializes in collections. That's all we do. I also was a judge for 5 years, and that's really helped in my litigation career. Most of my clients run the gamut, because the bottom line is that when money is owed, it really doesn't matter who owes it and who they owe it to. It's the same process. But typically, I represent businesses. I represent corporations like banks, leasing companies, manufacturers and distributors that have defaulted loans, defaulted leases, outstanding receivables. But what I'm going to tell you today applies to whatever your business is. And a lot of you guys are service providers. And service providers have just as much trouble, if not more, with collecting receivables than manufacturers and distributors. And I just want to help you with the specifics of your particular problems that arise in your businesses. And these, again, can apply. Like a lot of my clients are accounting firms, and I help their clients who have outstanding receivables. I also do M&A work when you're getting a company ready to be sold, purchased, acquired. They have to have their receivables in order, or it reduces the value of their company. So I know I'm always the type of speaker that if somebody wants to jump in and ask a question, I'm very comfortable with that, but Linda wants us to wait till the end, so whatever you want. So we'll wait to the end if you want. So essentially,
I don't think we're going to wait. Hang on. We're not going to wait to the end. If you have a question, just put it in the chat, and then Linda will call on. That's
okay.
So that way
Okay.
it's a little control. That's all.
And Tom, do you want to put up her PowerPoint?
She doesn't have a PowerPoint. So
Oh, okay.
No, I didn't do that, Linda, because sometimes it's distracting.
Sure.
You're so busy
I
trying to.
wasn't certain because of the opening screen. I thought there was a PowerPoint.
Yeah, no, I'd rather you just listen to me. So the first thing that I want to talk about is what's happening in this particular time frame with the coronavirus crisis, because dealing with your receivables is different today than you're experiencing in a normal time frame. It's different rules apply. I'm finding that I'm really changing my behavior in my dealings with how I'm handling receivables than I normally do. So the first thing is I just want to give you basic tips for when you're calling one of your customers or one of your clients, one of your purchasers, on how to handle the call. Because normally I am a real hard nut, and I am, you owe the money, what's the problem? You need to pay this. I don't run a charity. You absolutely need to pay this. But people are under such pressure right now. So the first thing that I want you to do is I want you to, when you call somebody asking for money, one of your customers, I want you to open the conversation by asking them how they're doing. Let them open up. And the reason why is because everybody's feeling very anxious, very uncomfortable, very insecure, and you want to make them comfortable talking to you. Because if they're comfortable talking to you, they're going to open up more. So I always start all of my conversations, how are you doing right now? How is this affecting your business? And information is so valuable in collections. So you want to sit there with your pad and paper, pencil and paper, and you want to be taking notes on what is happening with this customer. You want to ask a lot of information, and you want to talk to them about the status of their operation. How have they been affected? How are they dealing with this? And what's really important also is to get an idea of like what steps they've taken to help themselves. Have they gotten government assistance? That's really important. They're not going to openly tell you that they've gotten government assistance. You have to ask that. For example, my law firm, I applied and I received a PPP loan, right? So that just took an enormous amount of pressure off of me. Like I can pay a lot of vendors that I was sort of holding back paying because I got that government loan. But would I tell them that I got that loan? No. But if they ask, I would tell them. So that's, I think, really important is for you to go on a fact-finding mission and find out what's happening with your customer. If they ask for a deferral in their payment, if they say, I'm not making any money, I don't have anything, I'm really uncomfortable with you just saying, okay, let's wait. I'll give you 30 days to pay, or I'll give you 60 days, because 30 days, 60 days turns into 90, turns into 120. I don't think that you should be letting them not pay anything. I think that you should force them to pay something. Maybe not the whole bill, but ask them to pay half or a quarter, but get them writing that check. I think that just keeps you in the game. Because if money is tight, they're juggling a bunch of creditors. And so you want to make sure that you're one of the creditors that's getting, if not at least paid, but maybe even paid the most, more than other creditors are receiving. I just really insist on, even if, like I've had some debtors recently. I mean, I said, write me a check for $50. I don't care. I just want to get a check from you this month. And to me, I've seen that be very beneficial, because a lot of times when I say to them, you know, pay less than what you owe, but still pay, they end up paying more than I even thought they would pay. And then I really want you to ask them how they anticipate the immediate future is for them. Where's their business going? I mean, do they feel that as soon as the shelter-in-place orders are lifted, they're going to be back up and running? Is this going to be 6 months of slowdown for them? Has it affected their business for the next year? Because you want to decide whether you're actually going to continue to do business with them. If they say to you, this is really pushing them to the brink, you might decide not to continue to extend credit to them. So you really have to keep yourself informed on your customers, on what's going on. But do so in a compassionate, professional, courteous way, which, trust me, is not my normal way. So this is taking a lot of self-control and effort on my part. But the key to collections, the key to maximizing recovery is all in psychology. It's really understanding who you're collecting from, what their challenges are, and how you can maximize their payment to you. So I'm gonna go now. I see some questions, there's some chats. Do we wanna take some questions now or keep going?
I would love it if you would keep going, because I'm organizing the questions as we go, and
okay.
I'm going to get every one of them answered.
Okay. So the next thing that I want to talk to you about is I want to talk to you about the warning signs. The warning signs that you're not going to get paid, that you're going to get stiffed. And I think you have to really look at these warning signs with your eyes open and figure out whether you're going to continue to extend credit, whether you're going to continue to do work for this customer if these warning signs pop up. The first one, obviously, now it's really interesting with collections, because you have to first look at who you're talking to. Are you talking to a millennial? Or are you talking to a boomer? If you're talking to a boomer, you're probably going to pick up the phone. That's the most intimate, comfortable way of communication. If you're talking to a millennial, they are much more comfortable with emails. They're much more comfortable. I mean, I don't know, you might even text some of your customers, your clients. I have a couple of clients that I have given my cell phone out to, that I do so much work for them that they shoot me texts all the time, and I'm comfortable with that. But I think, number one, I want you to figure out who you're trying to get money from, who your customer is, and I want you to communicate with them on their comfort level. So not just your comfort level. I'm a boomer, so I'm very happy to pick up the phone. But I know that there are some of my customers that won't pick up the phone. So then I will email them. So the first thing I want you to do is figure out who your customer is, how you typically communicate with them, and I want you to reach out to them in that way. So if you typically talk to them on the phone and you call them and they're not calling you back, that's a problem. That is very disconcerting, particularly in these times when they're not going anywhere. They're available, right? I mean, it could be in a normal time, they might be on a business trip, they might be traveling, you know, whatever. I mean, I might be in a trial, you know, there are times when you can't return a call, but now everybody should be returning their calls. So if you're calling them and they're not calling you back, big red flag, okay? Big red flag. Like, I don't want you extending further credit to them, doing more work for them if you can't get a hold of them. You need to stop what you're doing before you get a hold of them and tell them that. Say on the phone, I'm really uncomfortable, you know, doing more work under our agreement until I touch base with you. And that's reasonable. The other thing is that if they're a millennial or somebody that you typically respond to emails, you know, communicate via email, are they not responding to your emails? Or are they, you know, sending you something like, oh, I'm super busy right now, I'll get back to you. And then a couple days go by and they don't get back to you. So if that is happening, again, problem, you know, like, really, you need to make this a priority because you might not get paid here, or it's going to be a late pay, really late pay. And then the other thing that I think is a huge red flag is if you can't get them to commit to a repayment plan. You know, I understand if they say, I don't know if I'm going to be able to pay all of it back to you within 30 days. Maybe I will, but there should be a basic overall outline of what they can pay to you. And if they won't commit to anything, if they won't commit to like monthly payments, or I think, again, problem, big red flag. Don't do any more work on their account if you're not getting some sort of promise of a repayment. So these are the warning signs when you're dealing with late pays. And the other thing that I really want to talk to you about is I want to talk to you about when you extend credit to somebody, when you do services for them and they pay you after the service is done, that's extending credit. I want to know what you're doing to protect yourself in this situation. Now, most people, most business owners, most service providers, we are so happy to get a client or a customer. We're so excited about the new relationship that we're not focused on a written agreement to protect ourselves. We're just focused on getting started with the relationship and going forward with the work. So many of you don't have written agreements with your customers, or if you have written agreements, they're out of date, or they're old, or maybe they're not signed, or they're incomplete in some way. Now there's no, I'm not telling you shame on you, because I just explained to you why this happens. But really, this is a really good time right now with the coronavirus and with people being late pays, and with you having more time probably to fix this, to get those written agreements in order. And that's not unreasonable. You can say, hey, I had some extra time and I was going through my file and I just realized I've got your written agreement here, and you know what? We never signed it. can I ask you to give me a quick signature, you know, or here's what people do when they have a lot of time. They start cleaning out their files or, you know, whatever. So it's not unreasonable for you to expect these things. Now, I want to talk to you about these written agreements, and I want to explain to you, if you're not going to have them drafted by a lawyer, which you don't have to have them drafted by a lawyer, but what you should do is there are certain things that you should have in these written agreements. It's really important, and I'm going to explain to you why it makes such a big difference having them. So the first thing, and I know this sounds crazy, but it needs to be signed. And I can't tell you, even me as a collection lawyer, I have written agreements that I never got signed. And I was like, oh, who cares? You know, the relationship's going forward. I'm making a ton of money. Everything's fine. Well, it's fine until I need that written agreement. And then it is really not fine. I won't name his name, but I had a provisor's member who came to me, who was owed, he was owed 20 grand, not a lot of money, but 20 grand, okay? And he was a service provider. He did a lot of work, and they didn't pay him, right? So I said, okay, do you have a written agreement? He goes, yes, I've got a written agreement with all the terms. And he gave me the written agreement, and I said, but it's not signed. And he goes, well, no, I mean, we never got around to signing it, but all, you know, we worked all the terms per the agreement, so it is our agreement. Well, the judge didn't see it that way. The judge said, hey, if you don't have a signed agreement, I'm not going to give you any of the benefits that agreement gave you. So, and even though I tried to argue to the judge, but, you know, it was a meeting of the minds. They really did intend all of this. The judge said, sorry. So it is so important to get those agreements signed. And I know you don't, you know, when you enter into a new relationship, it's like when you start dating somebody, you know, you want them to see you at your best. You don't want to be difficult. You want everything to go smoothly. And so you're uncomfortable asking for certain things. But that's a mistake. It really is, because if you're going to do a bunch of work for somebody and you're going to ask to trust them that they will pay you at the end of doing all that work, you're entitled to protect yourself. What you're asking for is not unreasonable. So you need to think about that. The other thing is, it's really interesting. So, and I'm going to tell you, I was guilty of this. I have a lot of clients that I've been representing for years. I mean, I have one client I've been representing for 30 years. So they switched credit managers, and the new credit manager that they had was not a good person, and he wasn't like the old people. And so I was starting to have trouble with a customer that I've been representing for 30 years. So I went back to my agreement because I was sort of at the point where I was going to need it. My credit agreement was my retainer agreement was 30 years old. That was like before email. I mean, it was so out of date. It was so ridiculous. I couldn't even, it was like, I think I typed it on a computer, okay? I mean, on a typewriter. I could never, ever turn this into a judge or into like a mediator and to have it taken seriously. It was ridiculous. I should have updated my agreement over the years. There would be nothing unreasonable about me doing that. It was a huge mistake on my part, and I suffered for it. And my 30-year-old client is not my client anymore because they hired this new guy who was very difficult, and I couldn't protect myself because I didn't update my credit agreement. So shame on me, and I will never make that mistake again. Now, the other thing also is I want to explain something to you. So when you have an agreement and when you're relationship sours, what is in your agreement dictates the terms of your relationship, regardless of how you behaved. So in other words, if your agreement says, this customer has to pay me every 30 days, but your customer was actually always paid you after 15 days, he was doing that out of the goodness of his heart because the terms of the contract dictate the relationship. So you really want to look at your written agreement and make sure that it has the terms that you want it to have. So if you want to get paid when the work is done, immediately, balance due upon receipt, then your contract needs to say that. But it needs to say when you want to be paid, because if it doesn't say when you want to be paid, then somebody can argue, well, I mean, I'm going to pay them in 6 months because their contract doesn't say when it needs to be paid. So it's something so dumb as that. It's so minute, but it really, really can be a problem when you're arguing that you have money that's owed you. The other thing that's really interesting is that a lot of contracts, the signature line, so you sign the signature line, and then you put it in the drawer, and you don't look at the agreement again for 5 years, whatever, 3 years, whatever. And you look at the thing, and you can't read the signature because who can read anybody's signature? My signature is completely illegible. So what has happened is a lot of people have said, I don't know who signed that. I can't read that. I don't know that that's my signature or my employee's signature. So in order to protect yourself from that happening, you need to have in your agreement under the signature line, you need to have a print where you print the name so you can read who actually signed this agreement. Now, I not only want you to put under there, print the name, I want you also to put title so we can identify who that person is. And I also really want you to put an address. And now that may sound stupid, but that helps us on the back end find a person if we can no longer find them. Because if I'm going to hire, now this might be a customer that you're dealing with all the time and you know where they are, but it might be a customer that you're not dealing with all the time and they come back to you and it's a different person and you might need to find that old person. So who signed it? I mean, you can't believe how many things come up when you're disputing a written credit agreement that you're like, who would have ever thought about that? Who would have thought that that would have been a problem? But it does. So the more information you have on your credit agreement, the better. The other thing that I really want you to do is I want you to put the federal employer tax ID number on the agreement if you're dealing with a business. Because there's a lot of businesses that will say, oh, they're no longer in existence. So, but we can't trace them unless we can identify them. It's like a corporate social security number. So, because a lot of times, like in my long-term relationships with clients, companies get bought. Mm-hmm. They get they merge, they morph into, they change the name. So we need to follow that. So we need to make sure that the entity that we want to collect from is the entity that is on that agreement. And for that reason, that's why you should annually, like say I'm going to do it in December or January, you should pull out those credit agreements and update them always, because information is king in collecting.
Wow. Lisa, I have to tell you, you have shared things already today that I've never heard ever on planet Earth. including what you were just sharing about the extra details to include on credit agreements, on
Linda,
signed agreements.
it is so important, and people don't realize, like, it's crazy to me because everybody's on a budget, right? Everybody's trying to save money, okay? I don't want to hire lawyers. That's the last thing I want to do because I'm really competent and I think I can handle it myself. But you don't know what you don't know. And somebody like me who's been in the trenches for 34 years, I have seen things that now I won't make that mistake again. I won't do that again, but I had to get burned to see those things. So a lot of people, Linda, just don't even know about this.
Right.
You know, other things. Okay, this is very interesting. So ask them to put their cell phone on the agreement and their email. Now, the reason why I want their cell phone is because nowadays people don't change cell phones. They keep them forever. So if you have the corporate phone number, you know, they're going to go out of business, they've left or whatever, but a cell phone, oh my gosh, I have people, I mean, people don't change. So cell phones is a great way to be able to get a hold of somebody if you need to. And that's information you're not putting anybody out by asking for this. I mean, anywhere you go, you fill something out. You write your cell phone and your email address. And so people don't think that, but on the back end, it's going to help you. Now, the other thing is that it's so important to put a clause in your agreement asking for, saying that in the event that this agreement goes into default, I can recoup my collection expenses, including attorney's fees. The reason why that is so important is because if you do have to sue, which, you know, hopefully you don't, but if you do, you can recoup all of your expenses, and they can be substantial. And that way, when you recoup the money that's owed you, you're not out anything. You are just out, you're not out anything. You get to get all your attorney's fees back. That one little line, if you don't put that in your agreement, it could make it not worth for you to actually sue, because all you're going to hope to get is what's owed you, and then you have to pay an attorney. So, you know what? Most people say, you know what? I'm just going to write it off. It's not worth it. The other thing I want to encourage you to do is, most people don't know this, but now small claims court is $10,000, which is substantial. And you can go into small claims court. It only is like $60 to file the suit, and then you can get them sued. So it's really not a lot of money to sue in small claims court. And also, you get to court really quickly. You get a trial in like a month. I mean, I don't know when the courts reopen, it might be delayed, but it's fast and it's cheap. And, you know, $10,000, I mean, if you're owed less than $10,000, it's a really nice option.
Fantastic.
And
you know what I'd like to do is, what I'd like to do, Lisa, make a note of exactly where you were in your notes, because I do want to make sure we come back to them, and I want to pose several questions that have.
I mean, I'm done, basically. I mean, I want to help people with their specific problems, so ask away.
No, so what's perfect about this is you've really addressed everything from the mindset of who the people are that we're communicating with, and the conversations to have. One question I want to pose before we go into all the rest of them is, right now, while we're in the midst of all the turbulence, is there a best time to reach out? Should we be systematically reaching out to every client to have that relational conversation so that we're not just having collection calls?
Yes, and in fact, this is not just in the coronavirus time, but this is all the time, is that if you're a service provider, particularly if you're a service provider, I want you to contact, just shoot your client a quick email when something is done, and just say, I just want to make sure we're good. Everything's happy. You were happy with what I just did for you, because not only is that marketing, not only are you, reinforcing the relationship, but the other thing also is you are securing data. If on the back end, the guy comes back and says to you, you know what, I was never happy with your service in the first place. You can go back and say, you know what, mister, I contacted you 5 times during this relationship, and each time you said everything's great. So, I believe that communication is the most important thing you can do with your clients. Just check in. It just keeps you in front of them. It doesn't cost you anything. And we all have more time than we're comfortable with right now. So I'm on the phone all day long to my clients, just going, what's happening? How was your day? Why not?
Fantastic. So then if those warning signs and red flags have popped up and you're preparing yourself, you're getting on the phone, you're starting the conversation, should we have a hierarchy about, if they haven't yet missed a payment, is there a conversation we want to have, versus if they have missed a payment, then should we be offering extensions or offering discounts for immediate payment? Or, is there a hierarchy of what to propose to them? Or do we ask them what they want to propose to us?
Yes. So collections is an art. It's not a science. And so you really need to take this on a case-by-case basis. I don't want to say to you, across the board, do this, this, and this. That's a mistake. I think you get a gut feeling from each customer of yours whether they're going to turn into a problem or not. You look at the history of the relationship, you look at, through your conversation, what's happened. And I think the most important thing is to set goals with them. So say, Joe, I need to get a payment by Friday from you. I just need to. We are, my company is instituting a policy where we're not accepting these to go past 45 days without a payment. So, and what you have, and I'll also, sometimes what I do is I try to elicit compassion. What I have to say is, Joe, I've got to make payroll. Like I did the service. I really need you to honor this relationship and pay me. So, because he's so busy worrying about what his problems are, he needs to be redirected to what he's created a big problem for you. So, Linda, case by case, but hold their feet to the fire, like get a payment in within a certain period of time.
Great. And then Jim, why don't you unmute yourself, because you had a question with regards to under circumstances of bankruptcy.
You're muted, Jim.
Jim,
question
you're muted.
is, I think it's off now.
Okay.
My question was, if you, I've got a client that is thinking about filing bankruptcy, and so before doing anything, I've urged them to make payments on a regular and consistent basis in the normal course of business, and not to discriminate in favor of anybody. How good is that in protecting yourself against a clawback from the court or from the trustee?
Clawback, you mean the 90-day preference period? Is that what you're speaking about?
Yes.
Okay, so
Lisa, for those of us who don't understand any of that terminology, would
you so when a company or an individual files for bankruptcy, right? So the job of the bankruptcy trustee, who is in charge of the bankruptcy, is to gather all of the assets of the bankrupt party and distribute them fairly. That's his job. And so one of the laws of bankruptcy says that any payments that that individual or corporation made within the 90 days before he filed for bankruptcy have to be returned to the party, to the bankrupt party, so they can be just spread out fairly. And the thought process behind that law is that somebody might have been pressuring and coercing the debtor to pay payments right before he filed bankruptcy, and so we want to get back that. We want to avoid that kind of pressure. That's what Jim's making reference to. So, and what Jim was asking is, how can somebody protect themselves from not having to return that money? And the question is, the answer, Jim, is that you cannot. You can not return it and hope that the bankruptcy court doesn't force you to, but they can force you to, and they usually do force you to. But I don't ever willingly give back money. I wait until I've been ordered by the court to return it. And sometimes they don't. Sometimes you get away with it. But you can't, the law protects bankrupt parties. They don't allow you to have the bankrupt party sign away his rights in that situation. He can't sign away his rights to
Great. That's helpful. Thank you.
Yeah, thank you. So you brought up all these amazing details with regards to the agreements that every single one of us need to go back and reconsider how we've written our agreements and so on. And Tom has got a very specific question that I think is the reality for many of us. Tom, why don't you go ahead?
You're muted. Oh.
Yeah, there we go. A very common thing happens to me is that I send people an agreement. It's got lots of fine print, let's say 1 page of fine print. And invariably in the middle of the relationship, the client gets very upset with me about something. And I said, well, it's in the agreement. This is what you have to do. And it's obvious they haven't really read it. They just signed the darn thing and went on. And of course, you can just say that's the way it is. But is there a way to handle that, to get them to look at things beforehand so you're not having that really uncomfortable conversation about terms that were there? They've been there the whole time. They signed it.
Yes. So one of the things that I do is I draft written agreements for people. And I don't use that kind of an agreement that you are speaking of. I don't like a lot of fine print. I think it's intimidating, and I think it's misleading. And I think that you can pretty much reduce your relationship to a page or a page and a half. It doesn't have to be a bunch of fine print. It's really simple. You are going to do this work. You expect to be paid within this time frame. If you don't get paid, this is what's going to happen. I mean, I think you could probably read through your agreement, Tom, and half the stuff you could cross out as not necessary. And, like attorneys are so up their butt, because they think that if you put a lot of little language in it and everything's protected and whatever, they think they're being so clever. But you know what? You're not being clever. A lot of people, you can be so clever, you can shoot yourself in the foot by somebody coming back and saying, well, it's in the fine print, I didn't read it, it's not understandable, I'm not going to be held to that language. So keep your agreement simple and clear. You know what I do? I make my kids read agreements that I'm not sure about, and I ask them if they understand it.
That's a great
and if they understand it, I'm like, okay, it's a good agreement.
No, that's really great. That's a very good idea. What I'm thinking about in particular are things like, with me, if someone really slows down a process and all of a sudden we're 45 days in and they haven't got me information and I haven't been able to move the process forward, I put a little clause in there saying that there's a restart fee. And and I usually don't do it until 60 or 90 days, frankly. I mean, I'm really not, but it is hard to restart a project. So would it be a good idea if there's something like that, that I just feel is reasonable and people have to know about, if I make them initial it, is that the way to get them to pay attention to it?
I would just, you know, what you're saying makes perfect sense, because a lot of times what happens, Tom, is that somebody enters into a marketing, like I've done this. I entered into a marketing relationship with a specialist, and I was like, okay, I'm going to spend, you know, $2,000 a month, and I'm going to do this, this, and this. And then I had a couple bad months. So I called my marketing expert and I said, you know what, let's just put everything on hold for right now. I can't really spend this money right now. And I was only thinking about myself. I wasn't thinking about the marketing person who has to just stop what they're doing. So you can put that in a paragraph in your agreement in very simple language, or you can talk to them that makes it reasonable for you to have to charge some sort of fee to restart it, because the relationship, you know, flow was interfered with. But I really believe in simple, understandable language that, you know what, because you don't have to have them initial, because if we put your contract in front of the judge and the judge reads it, he's going to say, oh yeah, you know, this makes sense. What about this didn't you understand? You're going to hurt yourself. You hurt yourself if you make it too complicated, because the judge said nobody could, who could understand this? This is ridiculous.
Fantastic. There are two more questions. One is going back to, so you're on the phone and you're having a conversation with that customer or that client. If through all of the suggestion and conversation, you cannot get them to make a promise to pay, where do you go in the conversation?
Well, you threaten in a very nice sort of way. Joe, I have to get a payment in here by Friday. If I don't get a payment from you, I have no choice. I have to turn this over to counsel. Well, you're putting me in an impossible situation, Joe. Please, just get me $100. Write a check to me, something, so that I don't have to turn this over to my collection.
And can we ask them for a credit card number, et cetera, and put it?
Hey, if you take credit, if you know, then yeah, you know, Joe, I would much rather have a check, but if you can't give me a check, then I need your credit card. You know, like basically put it back on him. You're putting me in an impossible situation.
Cool, thank you. And then, so here's an additional one. Many of us, in addition to being service professionals, we actually are advisors to clients who have their own clients who have customers, and so on. With everything that we've talked about during this past hour, what should we be advising our clients to do? Is everything we've talked about transferred directly to what they should be doing as well?
Yes, but in a different way. For example, okay, so like Jim represents a lot of manufacturers and distributors, okay? So now, typically in my manufacturing and distributing customers, what happens is that they deliver merchandise. It needs to be paid within 30 days. It's not paid within 30 days. Jim gets on, or his client gets on the phone, calls, and then a couple months down the road, the client calls and says, oh, I wasn't happy with the merchandise. It was defective, or the shipping was damaged, or whatever. And they never complained about it before, but now when it's time to pay for it, now they're complaining. So what Jim should be telling his manufacturers and distributing clients is, you need to shoot an email or a phone call or whatever you do when the merchandise is received. Did you receive it, and was it satisfactory? You know, it's really interesting, Linda. I do a lot of shopping on Amazon, and now I notice that number one, I get an email your product's been delivered. So, I mean, like I was last night, 9 o'clock, okay, right? I'm in bed watching TV and my phone dings and they said your package was just delivered. So I went downstairs out to the front gate and they had delivered my package at 9 o'clock. I was like so grateful that I got that email because it wasn't going to sit in the sprinklers, you know, and I just thought that is so great. So now they've acknowledged that now I know it's been delivered. The second thing is that now I'm noticing that I'm starting to get emails from the manufacturer saying, can you rate my product? Were you happy with my product? So if Amazon is doing this, we can do this, right? So I really think that if you're delivering product, if you're a manufacturer or distributor, you're delivering product, you need to have your IT guy somehow set up emails to go out that say, did you get it? Acknowledge that you got it. Was it, you know, did you get it timely? Like have them acknowledge that you got it and were you satisfied? Because like, in other words, if Amazon sent me a thing like last night my package was delivered and then a week later I called them and said, hey, my package wasn't delivered, where is it? They're going to say, wait, we sent you an email a week ago. Why didn't you a week ago tell me it wasn't delivered? So they're protecting that was a lawyer who came up with that idea. Trust me on that. So, I mean, it's a marketing thing, but that was a lawyer who did that. So that's my recommendation for manufacturers and distributors of product, not services.
Fantastic. Thank you. We've got some time left. And what I want to do is I want to open up the lines for Tom and Kenneth and Jim and Jeff to share what their takeaways are from everything that you've been sharing. So folks, why don't you go ahead and unmute yourself and share with Lisa if you've got any additional questions or if you've got a takeaway you'd like to share.
Or not.
Well, I'm also going to send out a quick poll, another poll, which is just like, what would you be interested in the next meeting to be next Friday? So I'm going to launch a quick poll so you can think about that. Are there any other questions?
Go ahead and unmute yourselves.
Yeah, and unmute yourself if they are.
So Lisa, this is Jeff, and what I'd like to, comment on, and it's interesting for me being in the insurance, some people are able to finance premiums, which right now is a kind of in flux with regards to, am I going to get a check? Are they going to pay the carrier, et cetera? So just being on the ball and not having the receivables stay out there too long. And then another thing is just keeping the agreements up to date is huge. That's it's a good way to get back in touch with your clients and check in and that, to turn it into a kind of a marketing opportunity also.
This is such a perfect time, Jeff, to do that because It's so easy to call somebody and say, you know what, I've had some extra time lately. I'm going through my files and I just realized we haven't gotten a credit agreement from you in 10 years. Can I send you another one? Can you update it? Nobody would think twice about that.
Yeah, in this time that we're in right now, it's funny, people say they have spare time. I've got no spare time. I'm busier than I have been, but it's good to put this kind of stuff, these are priorities that I should be working on.
Well, you have spare time on the weekends, Jeff.
Yes, I do. That's true.
Yeah.
Any other questions or comments?
Very well done, Lisa.
Oh, thanks. I appreciate that.
I'm a firm believer in ending as close to the right time as possible. Lisa, you did a fabulous job. Thank you so much for being my inaugural speaker. This is going to be recorded and I am going to email it out to people and also let people know it's available. So if you know anybody who'd be interested in this recording, please let me know. And it's great to see you all and stay out of trouble. Have a nice weekend.
Thank you, everyone. Take care.
Take care. Thank you.
Take care, everybody.